First Citizens v. DNA Holdings. It's case number 15644. Anyone here?
Good morning, Your Honor. Eric Swedbelt, First Citizens.
Good morning. Did we add a motion to strike onto your for you for the docket today?
Yes, we did.
Okay, not a problem. So I'm going to recall you briefly then when we recall the UMC. Okay, let's finish up with our case management first. Okay.
All right. Thank you.
Thank you. First Citizens is here. I think we added I want to say, motion to dismiss.
Correct, Your Honor. It's a motion to strike jury and Eric Swedbelt for the plaintiff. There is a court report.
Sure.
Good morning, Your Honor.
Anyone here for Dean, James, or DNA Holdings?
Yes, I'm here for both parties. James.
Mr. Dean, you're here for both parties?
Yes, ma'am.
And are you an attorney?
I am not.
Okay, so you cannot be here for DNA Holdings. You know that.
Well, I own the company. I'm representing myself.
Doesn't matter. You can't be pro se for a company. Okay, so there's going to be an order today if there wasn't already an order reflecting that you need to get counsel within 10 days. Okay.
Well, we can't make any orders at this point. You don't have jurisdiction to even hear today's CMC nor the motion to strike.
Right.
I challenge jurisdiction.
I'll decide that. Okay.
Right, but that does need to be decided. You need to decide that before we came here today because I filed a motion for clarification.
Mr. Dean, you just sat through our entire motion calendar. I can tell you if you have sat through motion calendar again, I don't think I have ever muted anyone. Okay, but if you speak out of order again, I will mute you. Okay, no more warnings. Go ahead, Mr. Swedbelt.
Yes, Your Honor. The motion to strike jury demand. This was an agreement, a master equipment finance agreement, and personal guarantee that were entered into by the parties. In that agreement, the parties agreed to waive a jury trial. I've cited case law out of the third DCA that support that contractual agreements to waive jury trial are fully enforceable in Florida. On public policy grounds, there's no public policy in Florida not to enforce a jury demand. Parties may waive their jury demand by contract, and that's the basis for the motion to strike the jury.
Okay, let me ask you for some background, and then I want to hear from Mr. Dean on his representation of himself. It looks like the reason this case is over a year old and still here is that you didn't serve the parties and the parties didn't answer until December of 2023.
Yes, Your Honor, we had difficulties with service of process, and we filed a motion to serve by other means.
Well, it doesn't matter. You got service, but that was the delay here. I just wanted to be sure.
Yes, Your Honor, that was the delay. And once we obtained, I guess, email service on the corporate defendant, Mr. Dean filed his answer and request for jury demand.
Got it. And has the corporate defendant answered yet?
No, Your Honor.
All right. What are you planning on doing with that?
Well, I was treating Mr. Dean as representing both his company and what I've done is filed a motion for summary judgment. And with respect to setting that for hearing, I've been unable to coordinate any hearing whatsoever in this matter with Mr. Dean. We welcomed the CMC that was set for today.
Not a problem. Okay, so Mr. Dean, what's your position on the motion to strike the demand for a jury trial that was filed on January 3rd?
My stance is that this is an ambush tactics employed by this court. I was notified of this motion for this hearing yesterday afternoon, which would be 0 days notice, as opposed to the law rule 1.090 subsection D that requires 5 days minimum for service, which I'm certain this court knows that, and still this court unilaterally scheduled this motion which is why I'll be filing a motion to disqualify this judge later this afternoon. But this court has failed to establish jurisdiction because I filed a motion for clarification on why the last judge was recused. She claims to be recused for sua sponte, but 2 years in, she recused herself 2 days after I filed a motion to disqualify her, thereby basically handcuffing me and saying she left by herself, so now I can't challenge her old rulings, which is unfair. I need to be able to challenge her old rulings because her service of process was unfair to me.
Mr. Dean, I want to make sure that I understand your arguments on this motion. We're not here, I don't know anything about a prior judge or a prior case or recusal or any other motions that you filed. The only motion set for today is the motion to strike the defendant's demand for a jury trial. So if you have any legal arguments against that, Mr. Zweibel argued that you signed an hang on. Mr. Zweibel has argued that you signed an agreement where the parties agreed to waive jury trial. I did review his motion, and you did sign that agreement. So what's your legal argument as to that? Because that's what I have to.
Sure. Okay. So you saw that agreement too, which is a contract that it says in the contract it's dictated by the state of New York law. It says it in 2 different sections. So for you to see that and still proceed today also extremely concerns me.
Okay. All right. Thank you. Mr. Zweibel, what's your rebuttal?
The case of that I cited, Credit Alliance versus Westland Machine Co. Was a jury waiver under New York law, and the case specifically said that contractual waivers of jury trial are enforceable in both Florida and in New York. We've been traveling under Florida law, but under New York law, contractual waivers are also enforceable. We would ask the court to strike the jury demand.
I didn't see, Mr. Zweibel, I didn't see a motion to address any jurisdiction or to transfer the case to New York. Has there been a motion like that filed?
No, Your Honor. I believe what Mr. Dean is referring to is his motion for clarification filed on December 29th, 2023.
Nope.
With respect to, if that's not it, then...
Don't speak for me, please.
Okay, not a problem. Okay, so as to this motion is granted. I haven't heard a legal basis to deny the motion.
The fact that I was served yesterday the notice to this hearing.
Hang on, Mr. Dean.
This is an ambush. You're ambushing me.
Hang on. Okay, this is the last time I'm going to tell you that I will mute you if you speak out of order again. The way it works is a person files a motion, they set a hearing. Okay, if you just file a motion, I have no idea.
You said the court set the hearing yesterday.
Okay, now I'm going to mute you because you've left me with no choice. But I want to make sure that I explain this to you so you understand. The way it works is a person files a motion and sets a hearing. That's what Mr. Zweibel did. You come here, you present your motion. The opponent gets an opportunity to respond, and then the movement gets an opportunity for a rebuttal, and then I make a decision. That's how it works. And then the hearing's basically over. So I've made my decision based on what I heard in this hearing. It's on the record. If you wanna file another motion based on that, you're welcome to do that.
But you're aware that I was served this hearing yesterday by your office.
Mr. James, Mr. Dean, if you unmute yourself again, I'm going to remove you from the courtroom now. Okay? I'm trying to help you. If you would like to file any motion, simply file it and call my JA, and we'll get you a motion calendar. We can do that in a matter of days. Okay? There are several things that you could be doing on this case. As far as DNA holdings go, though, I am going to enter an order. I'm going to ask Mr. Zweibel to please do that, but we need to get counsel for DNA holdings, okay? So we're going to allow 10 days to do that. And then if you all have any other motions that you need to get set, just call the JA and set them. Not a problem, okay? Thank you. Have a great day. Thank you both for being here.
Thank you, Your Honor.
Okay, have a good day. That was actually unacceptable, but we'll address it later.
Thank you. Goodbye.